Recording now. Okay, so welcome Rebecca, Sari, Harry, and Millie to our first tutorial for this unit. And tonight we will have an overview about administrative law, and hopefully I'll get you to think about the questions I will be posing. But in the meantime, before we start doing that, welcome Josh for joining us. Can I ask you to say something about yourself? So feel free to use the mic if you like, but otherwise you could probably just use the chat box to say something about yourself. It will be helpful if you could say what year level you're in, whether you're in your first year or second year, and your state and city of residence, so we have a sense about where you might be. And then if you've studied constitutional law before, and after we've done this short introduction of ourselves, we will then start talking about administrative law. Do you mind doing that? I've actually muted everyone, but if you wish to use the mic to say something about yourself, feel free, just unmute yourself. And or otherwise, please say something about yourself by saying something in the chat box. And I've seen that Faraz has also joined us, so welcome Faraz. Do you mind saying something about yourselves? Just your year level, state and city of residence, and whether or not you've studied constitutional law before. So Millie is in her final year. She has studied constitutional law and lives in Townsville. Very good. Thank you, Millie. I live in Brisbane, by the way. And yeah, okay. So Josh is in his second year, part-time, living in Bundaberg. Wow, he runs a real estate office. Fantastic. Very good. For Harry, lives in Rockhampton as well. This is his second year. Have you had a chance to do constitutional law, Harry? No, okay, not yet. Okay. So it's important to ask that question about administrative law because there are some principles which are related to both administrative law and constitutional law, and which actually impose constraints on administrative law processes, as I will discuss in the course of this tutorial. So Josh has done constitutional law. Sari, she's from Cairns, and she just transferred from JCU, and she's currently studying constitutional law. Okay, thank you. How about Faraz? Faraz, are you happy to say something about yourself? Year level, state and city of residence, and studied constitutional law. Okay, so mainly all of us are Maroons, right? So did you see the game last night? The first two matches of the state of origin, given the fact that the Maroons got clobbered, I was thinking it was going to be unexciting, but I was surprised with the quality of the game last night, especially in the dying minutes of the game. It was really a great game. I had fun, and unlike a lot of you, because I don't really come from Australia, I live here now, but to me, a lot of the rules about rugby are still quite foreign, like, when does offside happen? When does somebody, when is somebody brought to the sin bin? What type of fouls compel the referee to send somebody off to the sin bin? So, yeah. So I still don't quite understand the game. And
it's your tablet. Then I let you put this in my tablet. When I did it, you didn't even have it.
Okay, did somebody try to say something, or do we have a? Because I ended up muting everyone. Did somebody actually want to say something? I wasn't too sure if that was background noise.
Yeah. Hi, Manjo. It's me, Faraz. I was just trying to do an introduction.
Okay, sorry.
You're all right.
I kind of heard a child speaking. Was that your son?
Yes, that was one of my 3 kids.
Okay. Very good. Okay. So Faraz, can you tell us something about yourself?
Yes, so I'm from Brisbane. I work full-time for PepsiCo. I'm a frontline manager, so I have a pretty busy life.
Very good.
Yeah.
Fantastic. Okay. Thanks for us for sharing that. So maybe at some point, I might have to read up on the state of origin because I'm trying to determine what's the difference between rugby union and rugby league and footy. I actually thought that footy is rugby league because I lived in New Zealand for close to 6 years, and I'm very familiar with the rugby union because of the All Blacks. And I just assumed that, rugby league is actually footy, and I got the sense they're actually different. My son was telling me he's more aware about, those games, but it's probably a difference in rules. So I'm going to look that up. Anyway, so let's start going. And thanks for spending the time to tell the class about yourselves and for joining tonight's tutorial. So after this session, you should be able to explain the purpose of the tutorials and how they will be run, and discuss and explain the role of administrative law, the relationship between the separation of powers and administrative law. Football is soccer. Oh, I'm familiar with football. I played soccer. I played football all the time. But I'm talking about the footy, which seems to be kind of rugby. It's like, they use the same rugby ball and they kick it around. And it's not it's not like the rectangular field that I see in rugby union, but instead it's it's that spherical circle that is being played. Okay. So we'll talk about principles and values of administrative law, as well as boundaries of administrative law. Let me just go quickly first to the tutorial. So our focus of having the tutorials is that, remember, we need to focus on student learning. So it's not so much about just us meeting, but we're hoping that because of the tutorials, you will actually learn more by, digging deeper into concepts and cases. And I wish to emphasize that that our tutorials will be a safe learning environment. So you shouldn't be afraid to ask questions. You shouldn't be afraid to come up with an answer, even if the answer might turn out to be wrong. The advantage there is that it is often when we make mistakes that we remember the lessons. The lessons are there to be learned if you've made a mistake. But at the same time, I'm never going to judge you because you made a mistake. That's, in fact, the reason why you're in school, because you want to learn, and the assumption is you are bound to make mistakes. So it's better to be making a mistake in the course of a learning environment instead of making a mistake out there when you become a lawyer. And, the tutorials provides you the opportunity to give oral answers, because when you become lawyers, and especially if you end up pleading cases in court and you represent clients in court, and obviously when you're dealing with clients, you do need to be quite strong in terms of your oral skills. And so the tutorials would be a great opportunity for you to exercise your ability to communicate. And then you will also be getting constructive feedback from me. Okay, so that's it. I kind of see Faraz raising his hand. Did you want to continue raising your hand for us, or was that for
that was for the introduction. I'm done. Okay, thanks, man. I'll just
Okay, very good. Thank you. So okay. So let's talk about administrative law now. So I begin by asking you, one good way of us having a better understanding of what administrative law is for you to think about your experiences with the system of administrative law. So and by looking at the agencies involved with administrative law, what decisions may have been made, what actions were taken, you will then get a better sense of what administrative law is all about and why it is important to study it, and how it can actually help you either as a person or as a lawyer to know more about administrative law. So the first question I have is, have you had any experience with the system of administrative law, particularly in dealing with administrative or executive agencies, either at the Commonwealth or state level? And have you had to ask for a reconsideration or review of an administrative decision? So examples would be, examples of Commonwealth administrative agency would be Centrelink, ATO, Medicare, Child Support Agency. And the one about Child Support Agency can be quite, when you get involved with it, it's not just about the law, but the emotional entanglement, because if you've got a child and you end up having to talk about the amount of child support you need to give, and it's through the child support agency that is involved, it's a very cumbersome process, and it's an emotional laden process. So I wonder if you've had a chance. Examples of state administrative agency would be like the Brisbane City Council in relation to parking fines, the Queensland Police, the Queensland Department of Transport and Main Roads, for example, about your driver's license. So if you've had, perhaps one or two of you could tell us about your experience with the system of administrative law, particularly talking about any of these administrative agencies, whether at the Commonwealth or state level, and what the decision was about, if it's all right, and whether or not you wanted to or actually decided to pursue an application for a review or reconsideration of an administrative decision. Would somebody care to share his or her experience about administrative law?
Hi, Manjo. I can see on your screen you've got Brisbane City Council parking fine.
Yes.
I just got a parking fine a couple of weeks ago for picking up my kids from the school. The weird thing was it was issued by the City Council. Apparently, someone had observed us parking near the yellow line. We were waiting to pick up the kids, and yeah.
Okay, that's good. Thank you for us. So, an example I had, and I was quite unhappy with what happened. It was a good thing that the police didn't issue a fine, was that at one time I had actually gone to church and I left my dog inside the car. I actually kept the windows open. And the problem with my dog is that I got him from a dog shelter. And he's not really, even now, he's not really used to being with strangers. So I suppose, somebody was quite curious and tried to look into the car and saw the dog. And maybe the dog, my dog at that time may have been quite aggressive. And as a result, that person then called the police. And the police, came to check on the condition of the dog. But it was actually early morning, and my car was parked under a tree, and the weather was cool. But in a sense, I'm not really sure if I should say that I was annoyed. But in a sense, I was annoyed by that complaint, because I'm not really sure if I could have been wrong. But I didn't really go away for so long. It was a dog, and I think it's quite common for us sometimes to leave the dog there. Although I've never done it again. But it was a good thing that the police did not issue me a fine, because I would imagine that the fine could have been expensive. Paying the fine would have been expensive, and there could have been a danger that they could even have, filed a criminal complaint for, abusing a dog, although that was never the case. But these are examples where when you deal with an administrative agency, meaning part of the executive, they can make decisions that affect you. So the Brisbane City Council is an example. It could be that, you want to contest or dispute a parking fine that has been issued because you felt that you were not violating any council rules. And so we have here from Millie a comment. I work at Legal Aid Queensland, and I have spoken to people before who have been appealing decisions made by Centrelink, both through in-house procedures and through the AAT after that. Yeah. So I think in relation to Centrelink now, I wonder where it is, but you know how the Queensland government, is it through the Commonwealth government, however? It's probably through the Commonwealth government now that a lot of the Centrelink benefits are now tied to the requirement that parents must make sure that their children are properly vaccinated. And I think in some cases, if they don't get vaccinated, if the children don't get vaccinated, then the Commonwealth government will refuse to pay certain Centrelink benefits. It can also be questions about somebody who is currently unemployed, and when that person may not receive employment benefits because that person probably failed to undertake certain programs which are required so that that person becomes more prepared to be in the workplace, or it could be that that person did not bother to apply for jobs, these types of things. But these are examples of decisions made by the executive that could affect us. In some cases, at the level of the Commonwealth, we can also see instances involving, immigration laws. And the instance could be that, for example, there have been many instances of New Zealanders who have actually spent most of their lifetimes in Australia, and so their entire family is in Australia, but they never succeeded or managed to become Australian citizens. And then they commit violations of laws in Australia, which makes them kind of undesirable. And as a result, they then get kicked out of Australia. And I think that is a thorny issue now between New Zealand and Australia. But that is an example, again, of a decision made by the executive, which impinges on the rights of someone. And when that happens, therefore, it will be important for us to know what is the recourse for somebody. Can somebody seek a review of an administrative decision? And when you speak of seeking a review of an administrative decision, what exactly does that mean? What are the options there? Does it mean you always have to go to court? Does it mean you go to the minister who may have made the decision? What if the decision was made by a delegate of the minister? What are the grounds for seeking a review of an administrative decision? And some of you may have come across ideas about the difference between legality and merits. And these are principles that we talk about more as we go through administrative law in the succeeding weeks. We've got something here from Joshua. As a principal of a real estate company, I personally deal with the Residential Tenancy Authority. They have a set of guidelines, yet those guidelines can be interpreted differently by each employee of the RTA. Fantastic. Thanks for raising that, Josh. And let me share a personal experience here. It's actually quite pertinent, if you don't mind, because it shows, the advantage of knowing about administrative law, and maybe perhaps sometimes becoming overconfident that because you know the law, you wouldn't be scared about pursuing seeking a recourse with certain administrative tribunals. So in particular, the Residential Tenancy Authority, because what has happened was that at my age, it's only now that I've had a chance to actually buy my own home. So I'm quite old compared to a lot of people, because I know that a lot of Aussies, when they're in their 20s, perhaps even in their 30s, they begin to buy their own homes. But as an immigrant, it took me a while to buy my own home. So finally, we bought our own house in Brisbane. So currently, we're staying in a rental. So this is a rental. You'll probably be surprised that at some point during the term, the environment has changed, and that would be because I moved to my new house. But because I'm in a rental, what had happened was that the rental agency then, they said, I've been here for the past 4 years, but the rental agency sent me a notice about a month ago saying that the owners wanted to move in. And then they gave me, I think, around the first week of September to leave. The problem, however, was that the house will not get completed until the first week of October. In fact, according to the builder, it was going to take them until about the third week of October. So there was a period of about a month and a half when I needed to leave the house because the owners were coming in, and then my house wasn't ready yet. I mean, my house, but obviously the bank, I owe a mortgage to the bank. And so what I did was that I had to, because I'm not very familiar actually with what goes on with the Residential Tenancy Authority, neither am I very familiar with the law in relation to residential tenancies. But after I reviewed it, and then I noticed, the periods for when a complaint can be filed, when the RTA may actually take cognizance of a complaint, and so on. And I sent an email to the rental agent that, look, guys, can you just give me about a month? Because even if you were to say that I am in breach of the tenancy agreement because I stayed beyond the period of the tenancy agreement, you need to go to the Residential Tenancy Authority. And if you end up doing that, by the time this is heard by the RTA, I would probably have left the place. But so, and then I said, which was really bad. I think I realized it on that was in bad form, because I said, oh, you may have forgotten I'm a lawyer, but that's something I will never do again. But it just suggests to you that oftentimes there is an advantage to knowing the law, and you're going to be all lawyers at some point. And saying so much about myself. But before and I'm going to leave this topic shortly, sorry. And I recall that I had issues about the child support agency, and I think because I had a child custody problem a few years back. And the fact that, I learned the law probably helped my ex-wife and I arrive at a resolution of the child custody issue, and also in relation to child support. So I'm just saying that, that there are, I think, huge advantages to personally knowing the law, and then at some point being able to apply them either in relation to yourself or to your clients. Okay, so that's good. So having said something about that, what is administrative law about, and why is it important to study administrative law? What do you think? You could pick up the mic, or you could say something in the chat box.
Manyo, it's Josh here, and I've only just started a couple of pages into our textbook, but from my understanding, the administrative law, or at least the understanding of it, is the link between, let's just say, the executive government or the executive and the people that it directly affects, and the way that the communication and the dealings between both of those two entities happens. Would that be correct?
That would be correct.
Okay.
So that's a crucial point, because if you remember, if you talk about the branches of government, the traditional branches of government would be the executive, you have the parliament, and then you have the courts. And it's quite unusual in a parliamentary system, because the executive is actually part of the parliament. So you've got the prime minister and the cabinet who are actually part of the legislature or the parliament as well. And we need to remember that when the parliament makes decisions, and those decisions are embodied in a law, they do affect citizens. So when the government passes a law pertaining to benefits, Centrelink benefits, or passes a law pertaining to how you can put up a business and so on, they do affect everyone. But these decisions, as embodied in a law or in a statute that's passed by the parliament, are not part of administrative law. Although, as we later on see, when a decision is made by an administrative agency, it's often on the basis of a statute or a law passed by the parliament, whether it's the Commonwealth Parliament or the state parliament. And so therefore, to an extent, when an administrative agency makes a decision, because it passes on the law, it in a sense looks at the legality of the law, but not so much because a decision made by an administrative agency definitively provides an answer to what the legal question might be. It just happens to have to apply the law, because any questions about the validity or legality of a law is something that belongs to the courts. And that is an idea where you talk about the constitutional system. And as pointed out by Josh, therefore, when you talk about administrative law, you're essentially talking about the executive. So you're talking about the prime minister and his cabinet, and the decisions they make, the policies they make, which affect individuals. And that's at the level of the Commonwealth. It could be at the level of the Queensland government, where again, they make decisions that affect us. It could be about rates that are imposed. It could be decision about driving requirements concerning driving, and because of these decisions that are made, it affects individuals. Individuals then have to determine whether they have certain rights, interests, or legitimate expectations which may have been affected or impacted by such decisions made by the executive, and what their avenues might be to have these decisions reconsidered, reviewed, or appealed. And then, so we examine later on whether the review can be done internally, it could be done by the courts, or it could be done by some specialist administrative tribunal. So that's correct. As Josh pointed out correctly, it's essentially about the executive and the citizens. So it's not about the parliament and the citizens, or it's not about the parliament as opposed to the executive, where the parliament may actually decide to kind of impeach or remove from office a member of the executive. That would be constitutional law. the administrative law focuses on decisions or actions made by the executive that impact citizens. And so, as pointed out by Sari, it's also really a way of regulating executive decision making, because can you imagine the power that is within the executive? They make huge decisions every day, you know, and it's not just so much about, so you have the parliament making a law, but oftentimes the laws passed by the parliament or the statutes can be quite broad, and the parliament therefore often leaves it to the executive to flesh out the policies, and these policies then affect the citizens. And so therefore, can you imagine if there were no system of administrative law, what do you do? If you want to question the exercise of executive power, when for example, like in the United States now, although it's a good thing it's not happening in Australia, but you've probably come across instances in the US where, or it could be in my Facebook feeds, which are kind of acting up, but you have a lot of instances in the United States where the police are quite brutal in terms of dealing with suspects. So they probably, you know, they shoot first and they ask questions later. You know, and the media has played up these incidents so that we begin to think that in the U.S. seems to be a very, you know, there's a lot of lawlessness going on in the U.S. And it would appear that in the United States, you have a lot of instances where there's police abuse. And can you imagine, therefore, where you don't really have a system of complaining against police brutality? That is an example. So if you can't go to the court system, to the criminal justice system, and you know the police do something against you, which could violate your rights. It could mean that, you know, while you were walking on the street, they just accost you, and then they start asking you questions, start frisking you. They want to check your bags and so on, and you want to question, you know, what appears to be an infringement of your constitutional rights. What is your remedy for that? That is an example, again, of administrative law. And so, you know, there is huge a huge amount of coercive power on the part of the state. And administrative law is crucial because it tells us what our rights might be and what the remedies that are available. And we will later on notice that when we talk about administrative law before, and in particular, when you wanted to question or have a decision by the executive reconsidered, what you had to do was you needed to go to the courts. So can you imagine if, because of a decision made by the executive, you had to go to the court system? You can just imagine the cost involved. And chances are it's difficult to self-litigate because you're very unfamiliar with the law, so you need a lawyer. And the court system is quite time-consuming because there is a legalistic and formal process to it. And so therefore, it becomes quite difficult for the ordinary person without the financial resources or the knowledge about the law to, you know, seek an appeal or a reconsideration of an administrative decision through the court system. But what has since happened was that in 1975, for example, you now have the Administrative Appeals Tribunal, which was established by the Commonwealth Parliament. And at the level of the Commonwealth, therefore, you now have a system, you now have an institution which officially reviews decisions made by the Commonwealth government, the executive government of the Commonwealth. And that is also, that type of system of review has now been since replicated in the States, so that in Queensland, for example, you have the Queensland Civil and Administrative Tribunal. And we're going to talk about the separation of powers in a short while, because we will realize that even when you talk about the Administrative Appeals Tribunal, what it essentially does is to examine the merits of a decision, whether or not a decision made by the executive was actually the correct or preferable one, as we encounter later on as a concept. But the AAT does not examine the legality of a decision. The legality in the sense that, is it really, is this the proper way that the law should be applied in a particular case? Because as we see later on, when it comes to legal questions are actually best left to the courts. So there is a divide between the merits of a decision, meaning going into the factual matters of a decision, as opposed to looking really at the legality of a decision, whether or not a decision was made according to law. And I think we have about 2 or 3 weeks, no, actually 5 weeks, where we talk more about the legality of administrative decisions, which actually mainly belong to the courts and not with the administrative appeals tribunals. We're going to have a look at that. Okay. Now, question 3. How would you distinguish administrative law from other fields of law? Example, constitutional law, or maybe even civil law. Can somebody try to attempt to provide an answer? How would you distinguish administrative law from constitutional law? Let's just focus on constitutional law, not civil law, just to make it simpler. You could either, raise your hand. Okay, so from Rebecca, the parties involved are different. Okay, very good. And we're going to speak more about that shortly. Thank you. What do the others say? Feel free to say something in the chat box, or you can just turn on the mic. So constitutional is the form of overarching entity. Okay, very good. And I'll pursue that idea in a short while. Constitutional is the forming the overarching entity.
Yeah, sorry, Manuel, I'm trying to type too fast. Look after a lamb and everything as well. So
okay.
My view is the constitutional law is the overarching entity over, let's just say, Australia, which then guides how the executive works, and then the administrative law, that's what we talk about next, isn't it? That is then, let's call it a subordinate within the Constitution, which deals between the entities. Would that be correct?
That's actually a very profound statement, and that is correct, because, and that's something which I haven't really thought about. That is correct, because you would only know more about administrative law, what it encompasses and what its limits are, by actually knowing about constitutional law. Because constitutional law mainly talks about the delineation between the powers of the executive, the legislature or the parliament, and the judiciary. So if you did not study constitutional law, you will have a limited idea about what exactly is the extent or scope of administrative law. But because you have a superarching, following the idea of Josh, you have an overarching idea known as administrative law, you now know that administrative law can be considered to be kind of a subset of constitutional law, or at least a subset of public law, which then focuses on the exercise by the executive of its powers and how they impact on the governed or the citizens. So that's a very good point. And this tells us that it becomes really helpful, and we're going to be discussing that issue in a short while, I think in the next question. It is important oftentimes to know more about constitutional law, because otherwise you begin to wonder, why can't the executive, decide legal questions? Or why can't the executive, for example, or the an administrative tribunal, why can't an administrative tribunal form a legal opinion as to the constitutionality or validity of a statute, and in doing so, actually strike down a decision? So for example, let's assume that a decision is made by somebody from Centrelink, and a person feels that the decision made by the Centrelink officer violates a particular statute. Okay, and in that case, therefore, what he would like to do is to go to the Administrative Appeals Tribunal to ask the Administrative Appeals Tribunal to make a finding that that regulation is actually contrary to the law. And in that case, would that be permissible? Because you're not talking about the legality of, a policy or, some memorandum that was passed by or issued by executives. Can the Administrative Appeals Tribunal, for example, make a determination about the legality of such an instrument? And on the other hand, the other question is, would courts, why can't courts examine the merits, the factual correctness, or the exercise of discretion by the executive? What's wrong with that? I mean, can you imagine you go to the court because you feel that a decision was wrongly rendered, and you raise the question about the legality of the decision, whether or not, in other words, it is according to the law. But at the same time, you're asking the court to examine the review by the court of the facts. And you're saying that the executive incorrectly made a finding. So what's wrong with the court? Why can the courts actually review findings, factual findings? Can the review say that, can the court say that, the judge, the executive officer incorrectly applied his discretion? And then we begin to ask, is that true at the level of the state? So in other words, as Josh pointed out, does this have something to do with the separation of powers? Yes, it does. And is there separation of powers in the states? So that at the level of the states, for example, an agency such as the Queensland Civil and Administrative Tribunal, would it be in a position to review decisions made by an executive agency on the basis of both the law and the facts? So in other words, is it possible for the Queensland Civil and Administrative Tribunal, for example, to examine the merits of an executive decision? So if you were to extend that, you can see a clear distinction between asking the question, can Commonwealth courts or federal courts examine the merits of an executive decision? And can state courts examine the merits of executive decisions? And the answer is, in relation to the notion of separation of powers, federal courts cannot examine the merits of administrative decisions, but at the level of the states, they could. And why is that? That brings you to the notion of separation of powers. And so therefore, I'm going to go back to this in a short while. And this brings us to the idea when we pursue, I think, question 4. I would invite you, therefore, to have a look at some notes I've actually added to Moodle. So I've talked about some key principles of constitutional law, but at the same time, I've added a study guide pertaining to constitutional law in Moodle. So please have a look at it. Now, they would enforce. So, Shosh, do you mind?
Sorry, that was in relation to the Commonwealth, whether the let's just say the judges or that particular court could look at the executive decisions or the merits of it. On a Commonwealth level, no, they would enforce. Enforce is the only word I can think of at the moment, but the executive would set the rulings, and then the judges or the courts would put them in place and make sure that they were to continue.
Okay, very good. So as we later, thank you for that. So as we later on see, at the level of the Commonwealth, we have a separation of powers. It's called partial separation of powers, but just to clarify, what it essentially means is that the courts will not second guess, the federal courts will not second guess decisions made by the executive, primarily because of the separation of power. So the executive is meant to be separate from the courts. So can you imagine if at the level of the Commonwealth, the federal courts can examine the merits of executive decision making? What it would essentially mean is that it becomes the courts, which the courts would then be kind of more superior to the executive, so that decisions made by the executive can actually be reviewed by the courts. But in our system of government, because of the separation of powers, courts examine legal questions, they examine the law, it is for the executive to make decisions about policy. It is for the executive to formulate policy as well. And for that reason, courts will not second guess and will not interfere with policy making, especially because one of the key principles in constitutional law is what is known as the principle of the principle of representative government. So that if you think about it, the executive actually are elected officials. They've been elected, by the people, and so therefore they embody legitimacy when they make decisions. So I mean, we don't really elect the prime minister directly, but because the prime minister is chosen by the parliament, it means therefore that the prime minister, as we know, then is actually in a position to kind of he embodies therefore the collective ideas and the collective legitimacy as reposed in him by society. And for that reason, it is oftentimes in constitutional law considered to be something of a political question. So if it is a political question, courts will not interfere. And these kinds of political questions usually relate to the exercise of discretion and the formulation of national policies, which are best left to elected and representative members of government. And courts obviously are appointive officials. So we're talking about the level of the Commonwealth. But if you took up constitutional law, we realize that at the level of the states, there is really no separation of powers. And as a result, to a great extent, what then happens is that at the level, because there is no separation of powers, what then happens is that it is permissible for state courts to actually examine the merits of decisions. And the reason why there is no separation of powers at the level of the states is that the states traditionally were colonies of imperial UK. And if you follow, therefore, the system of government in the UK, for example, there is no separation of powers, because what happens then is that in the UK, there is such a thing as parliamentary supremacy. So in the UK, such as well as in New Zealand, the parliament is supreme. And courts in the UK and New Zealand do not have the power to invalidate laws or statutes passed either by the UK Parliament or by the New Zealand Parliament. Courts don't have that. So in other words, there is a recognition that Parliament is supreme. And the idea about parliamentary supremacy in the UK and New Zealand, for example, is also tied to the idea that they do not have a written constitution. So they don't have a written constitution. And because they don't have a written constitution, there is nothing that would constrain the activities of Parliament. And through the years, historically, if you examine, there have always been conflicts in the 1500s and the 1600s between the monarch as opposed to the Parliament. And, in these struggles for power, it was the UK Parliament that prevailed, and it asserted its power over the monarch. So that in the UK, for example, while you still have Queen Elizabeth, that is actually largely a ceremonial role. And it is the UK Prime Minister, and now you have Theresa May, who actually makes decisions in behalf of the government. And because she, as Prime Minister, she and her party are in control of the Parliament, they can make decisions about what the laws should be. And when a law is passed, courts in the UK cannot invalidate a law. In Australia, however, it is different, because we have the Australian Commonwealth Constitution, and the Australian Commonwealth Constitution embodies the principle of the separation of powers, at least the partial separation of powers in the Westminster form of government. And it sets clear limits about the powers of the executive, powers of the legislature, as well as the powers of the courts. At the level of the states, as I pointed out, because states inherited these were colonies of imperial UK, and they inherited, therefore, the powers of the UK Parliament. which recognizes parliamentary supremacy, what it means is that state courts cannot invalidate a state law, except to the extent that the state law may contravene the Commonwealth Constitution. So that is the constraint there. But otherwise, if the state parliament, for example, passes a law and it does not violate the Commonwealth Constitution, state courts cannot invalidate such a state law. And so there is that idea of, you know, a lack of separation of powers at the level of the states, and because there is no separation of powers because of parliamentary state supremacy, state parliamentary supremacy, what it means is that it is perfectly permissible for state courts to examine not only the legality of an executive decision, but also the merits of an administrative decision. At the federal level, however, federal courts cannot examine the merits, the factual correctness of a decision or the exercise of a discretion by the executive, because that would violate the partial separation of powers at the Commonwealth level. Okay, any questions so far? Comments?
Just on that last point that you made there.
Josh, yes.
One example maybe would, I don't know whether it relates, is the Scripture Union or the Chappies in Australia.
Chappies?
There was that, the Chappies, so the Scripture Union school chaplains.
Ah, okay, go on.
So would the, excuse me, the ability to question the legality of it under the Constitution only be able to be done within the Commonwealth government, but if it was a state-run chaplaincy service, it would not have been able to be challenged. Is that correct?
I'm not very familiar with the factual background there. So we're talking of state schools that were ran by chaplains or churches. Was that it?
No, they were helpers. Let's call it. They were paid helpers. They're religious instruction helpers within the state schools.
Okay.
Yet there was a court case and it went to the federal government.
Okay.
They had to change the way that they were doing their funding in order for it to continue within the states. So I was asking the question, if the funding was provided by the state governments, would that have meant that it would not have been able to be challenged because of what you just mentioned before?
Okay. So assuming that the funding actually came from the state government, the fact remains that there are certain rights which are considered to be constitutional rights based either on the Constitution expressly or as implied in the Constitution. So there are certain rights. So what this would therefore mean is that although at the level of the states there is such a thing as state parliamentary supremacy, whatever laws are passed by the state parliament, for as long as it is under the Constitution something that the Commonwealth Parliament also has the power to legislate on, or it might be that there are certain constraints as imposed by the Commonwealth Constitution pertaining to certain constitutional rights, these would then be limitations on state parliamentary supremacy. So it's not just so much about state funding. It's also the question of whether or not when the state parliament passes a law, while it is true that state courts will generally not be able to invalidate a law passed by the state parliament, a state court can actually invalidate a state law because it violates the Australian Commonwealth Constitution. And so what this actually means is that state courts, or at least the state Supreme Courts, were actually part of although the state courts are not, the state Supreme Courts are not considered Chapter 3 courts. In other words, they have not been constituted according to the Australian Commonwealth Constitution. But in constitutional law, we have what is known as the integrated federal judicial system, so that at the level of the states, even the state courts form part of the federal judicial system. And so therefore, the state Supreme Courts have the power to invalidate state legislation for as long as the state legislation contravenes the Australian Commonwealth Constitution. Did that answer your question?
Yes, it did. Thank you.
Okay. My wife was telling me that sometimes she asks me a simple question and they end up providing a long-winded answer. Okay. Any questions so far before we continue? None? Okay. Okay, so let's just, having made some discussions right now, can I, when you think about it, decisions made by courts, so when courts make decisions, are they part of administrative law? Or in other words, can decisions made by courts be reviewed as part of administrative law? And how about the validity of statutes, for example? Would that be part of administrative law? So I'll answer my question. So if you talk about decisions made by courts, because courts are not part of the executive, they're part of the judiciary, obviously, therefore. And we talked about administrative law being about a system of rules and principles whereby the citizens and the governed can seek a review of executive decision making, or is a way by which executive decisions or actions are regulated. And so therefore decisions made by courts are not part of administrative law because courts do not belong to the executive. In relation to the validity of statutes in general, as we said, if you talk about validity or legality of statutes, that is a legal question and that belongs to the courts. That is part of constitutional law. It is not part of administrative law, except to the extent that, as we later on see, there will be instances when, simply because the validity or constitutionality of a law is raised before an administrative agency. So remember, executives make decisions on the basis of law. It could be a statute, or it could be a policy decision, or it could be a memorandum or an instrument that has been passed by the executive. So they do make decisions based on the law. I mean, that's the assumption. The question is, let's assume that in the course of somebody making a review, making an application for review before an administrative agency, does the mere fact that the administrative agency now has to consider the validity of the statute, does it now mean that the administrative agency will have to divest itself of jurisdiction and therefore, tell the party to go to the courts because the issue of validity has been raised? And we see that in the case of Brian Lawler Automotive versus New South Wales Collector of Customs, we realized that the mere fact that the legality of a law has been raised before an administrative agency does not divest that agency of its ability to continue to make a decision as to the correctness of a decision made by the executive. Any decision, for example, made, however, by the administrative agency that touches on the validity of the statute is not binding, obviously, in the courts. But certainly, executives, when they make decisions, have to pass upon the legality of a statute. And in doing so, that will also have to be examined by an administrative agency. But any determination made by an administrative agency concerning the legality of a statute is not binding on the courts. And it's a way of having to pass upon provisionally on the correctness of an executive decision. So I think we discussed as well the notion of why administrative law is important to the separation of powers doctrine when we talked about it. So administrative law is important because if there had been no system of administrative law, what would have happened was that there would be limited avenues for reviews of administrative decisions. Because remember, and I'm talking about the level of the Commonwealth. Remember that when the executive makes a decision, whether it's, let's say it's the Australian Taxation Office, or it could be the Department of Home Affairs, or pertaining to immigration, when the Commonwealth Executive Agency makes a decision, if you wanted to go to the courts, then because you're resorting to the courts can only examine the legality of the executive decision. And that therefore provides a very limited, a very narrow, as we later on see, a very narrow avenue for the review of executive decisions, because it can only be based on legality. But because of administrative law, which is actually a new concept, which only emerged in the 1970s in the UK. It's a very new field of law. Because, and we especially with the rise of the Administrative Appeals Tribunal in 1975, and we now have the AAT, we now have an agency, a quasi-judicial tribunal that is able to examine the merits of an administrative decision. So because of administrative law, when somebody is aggrieved by a decision of the executive, that person can now say, should I seek recourse on the basis of law, meaning go to the courts, or do I go to the Administrative Appeals Tribunal on the basis of questions about merits of the decision? And of course, as we later on see, there has to be certain jurisdictional requirements which have to be met before a decision can be appealed or reviewed by the AAT. And that is something that, okay, see you soon, Josh, before it can be reviewed by the AAT. Okay, so it's 7 o'clock, and I've seen that 2 of you have already dropped off. Before we end tonight's tutorial, would you happen to have any questions? Because if none, then we will end it tonight. Okay, so Millie also had to go. So I think we're good to go. So thank you very much for joining tonight's session. And so Saturday also has another tutorial. I won't keep you longer. Thank you for joining, and I'll see you again next week. Bye. Good night.